Chairman King, we are now live on YouTube, and whenever you are ready, you have the floor.
All right. Well, in this case, I'm going to go ahead and call to order via Zoom the Pitt County Board of Equalization Review meeting for April 20th, 2021. As always, we will start with a silent invocation, and then we will have the Pledge of Allegiance, which I know comes up with a flag on the picture. So we'll have the silent invocation. Amen. All right. We'll now have the Pledge of Allegiance. Let me see if I can adjust my screen. Cover up my camera at least. All right. I don't see the picture of the flag, so I am going to look out my window. Oh, what? I see one now. There we go. Look at that. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Oh, goodness, that was a nice flag. I noticed the $299 price tag on that thing. So. All right. At this time, Mr. Clerk, can you give us a roll call and make sure everyone that is on the meeting, make sure you make a noise and say that you're here.
Chairman King.
I'm here.
Madam Chair Huggins.
Here.
Andy Piner.
Here.
John Shepherd.
Here.
Jay Shackelford.
Is Jay here?
I'm here now. I'm doing this from my phone for the first time and having a little difficulties.
It's all right. We can hear you. That's good.
Can you see me?
No.
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 I don't know. Let's see if this works.
And Ed Congleton.
We can see you now, Jay.
Here.
Is Ed here?
Ed is here.
All right. Is that all of us? 7 of us?
Everybody but Commissioner Danny Smith.
Okay. All right. Well, let the record reflect that the Board of Equalization has 7 members. We certainly have a quorum today. In front of us, Ms. Heath sent out a revised agenda earlier. I think it came out earlier today, but it could have come out yesterday. I'm looking at it right now. Are there any additions to this revised agenda or any omissions or anything that comes on or goes off?
No, the revised agenda is what we have. We also might want to add or have a discussion about some additional board meetings, but I'll leave that up to you, Chairman King, if you want to add that to the agenda.
We'll just add that to new business.
Yeah.
All right. In that case, I would entertain a motion to approve the amended agenda.
I'll make that motion.
All right, John, I hear that. Is there a second to that one?
Second.
I think I heard Ed. Is there any discussion? Hearing none, all in favor of approving the amended agenda, say aye. And you're actually through a roll call. We got to do it through roll call.
Yeah. Chairman King.
Aye.
Madam Chair Huggins.
Aye.
Commissioner Piner.
Aye.
Commissioner Congleton.
Here.
Commissioner Shepherd.
Yes.
And Commissioner Shackelford.
Yes.
All right. All right, we got our agenda on here. The next item is for approval of the April 6, 2021 minutes. Those minutes were set out earlier. That was a meeting we had on Zoom 2 weeks ago. Did anyone notice any additions to be made to those minutes or omissions? All right, hearing none, I would entertain a motion to approve the minutes as published.
I'll make that motion.
I think I heard John seconded. So is there any discussion on the motion to approve the minutes? Hearing none, let's have a roll call vote on that. The motion is to approve the minutes as published.
Chairman King.
Aye.
Madam Chair Huggins.
Aye.
Commissioner Piner.
Aye.
Commissioner Congleton.
Aye.
Commissioner Shepherd.
Yes.
Commissioner Shackelford.
Yes.
All right. that brings us now to we actually have some business today. It appears that we have one appeal today, and it is a denial of application of present use value. We had some material sent out. This appeal is from Ag Carolina, who's the taxpayer, and it appears that they have multiple tracts in Pitt County, from what I can tell. Does that sound right, Mr. Clerk?
I'm going to let Lori English speak to this. I think this is just one track. Is that correct, Ms. English?
That's correct. They only have one parcel that's in the program. They do own other property, but we're only speaking of the one.
All right. Well, let's tell us, is anybody on Zoom from Farm Credit? I mean, from Ag Carolina?
Yes, Preston Sutton. I'm the branch manager here in Greenville.
Well, Mr. Sutton, it's good to see you. I should disclose to the board that I have I'm not conflicted out on this thing. I've never represented Ag Carolina themselves, but I know Mr. Sutton for many years of doing ag lending. And certainly I believe that I can be impartial in this case, but it is certainly good to see him on the video. And
Yes,
I don't know much more about than just reading the material. So in this case, I'm going to let Lori tell us what's going on in this one, and then we'll address it as we go.
Jeremy, can I interject a second?
Yes, sir.
Ag Carolina is a very good client of mine. I assume that I should probably bow out of this one.
Do you do work for them? Actually,
quite a
paid
bit.
work?
Quite a
Yeah.
bit.
I think that would, we have 7 here, so we would have 6 on that one. I routinely do work with Ag Carolina, but not where they actually pay me. So I feel like I can actually evaluate this one. But I think that it would be wise of you, if they, my feeling is if they actually write you a check, you probably ought to recuse yourself. That's kind of how I go.
They're a very good client of ours.
All right. Well, Mr. Shackelford, we will let you not consider this one and not even ask any questions, and let you preserve your relationship with both Ag Carolina and the county. How about that?
Chairman King,
Yes.
I would just recommend, just out of abundance of caution, that the board move to excuse Commissioner Shackelford from voting on this. It's a mere formality, but I think it's probably best to have that reflected by action of the board.
I think that that's correct, and that's been consistent what we've done before. And in this case,
recuse Mr. Shackelford.
all right, a motion for Mr. Congleton to allow Mr. Shackelford to recuse himself and not consider the appeal of Ag Carolina. Is there a second to that motion? I'll second it. Or Andy will say. Go ahead.
I have a discussion. I need to bow out as well. I need to recuse myself as well.
Do you do fee appraisals for Ag Carolina as well?
Yes.
Okay. All right. Well, let's see. All right. That leaves us 5 of us. 5 of us on this one. Okay.
I will amend my motion to say that Shackelford and Piner be recused from reviewing this case.
All right. Is there a second to that motion? It can't be. Go ahead.
Second.
All right.
And to the clerk, I don't think it's necessary to call those 2 members for the roll call vote when we get to it.
All right. So we have a motion on the board to allow Mr. Piner, Mr. Shackelford to recuse themselves from this appeal. Let's have a roll call vote on that.
Chairman King,
Aye.
Chairwoman Huggins,
Aye.
Commissioner Congleton,
Aye.
Commissioner Shepherd,
Aye.
and that's all. We have 6 commissioners here today, and we got 4 to hear this case. 4 out of
Okay.
7.
We have 6. We have 6 here, and we got 4 to hear. So we still have a quorum. We can actually do some business on it. Okay. All right. Well, one of the county, I'll call Mr. Sutton in a minute, but one of the counties set us up and tell us what this appeal is about.
Okay, so this is about parcel 11787, and it was in the present use program. And part of what we do is audit those parcels, and that parcel had not been audited prior to, since the time that they became owners in 2018. It was audited under prior ownership. And when we reviewed it, it just appeared that there was an issue with the ownership requirement. And when we looked at it, as they have to, their primary business is one of the requirements of ownership. The primary business has to be farming. And so, okay, that didn't appear quite right. So what I did was I went and looked at their information online. I looked at their financial statements that they have available out there and their bylaws, and everything appeared to me that their primary business was lending. And so even though the use of the property was proper, you know, it was agriculture, it was being farmed, they do lease it to a farmer, the ownership really didn't seem to meet the statute of primary business as far as farming. So I did contact the Department of Revenue just to get their opinion on it and make sure I wasn't missing anything. And I spoke to Doug Huffman there, and he said, based on what the information I provided to him, that sounded correct, that they did not meet the ownership requirement. And he said, in addition to that because the land was being leased, the proper ownership would even further have to be all of the members of this company would have to be relatives of each other in order to lease this property out as well. And so it just couldn't meet that primary business standard. So we did remove them from the program. It was a little bit complicated because they really never should have qualified when they were put in 2018 when they became owners. And so we had to treat 2018 as that disqualifying event, which meant that they were billed for 15, 16, and 17 deferred taxes. And then the 2018, 19, and 20 had to be treated as discovery. And so Chris McLaughlin at School of Government had written a really good blog with almost an example exactly like this one. And so we were able to treat it that same way. I also reached out to Chris to be sure about appeal deadlines, because discovery carries a 30-day appeal, whereas present use removal carries 60-day. And I wanted to make sure they had enough time. And so I wanted to make sure I was okay doing 60 for both, which he advised that was fine. And so we rolled them out and we sent the bills to them. And I did speak with Mr. Sutton before as well, just to kind of explain it a little bit better. And they did submit payment for some of what was due, but not all of that. And I think that's the information you need, but I'd be glad to provide something more if you have a question.
All right, I think I understand the nature of this appeal. So this property transferred in 2018 from a prior owner who actually was qualified in the present use value program to Ag Carolina, correct?
Correct.
It was already enrolled in the program. So in 2018, Ag Carolina took ownership. And so the determination of whether they should be eligible for the program should have been made in 2018, but for some reason it wasn't. Is that correct as well?
Yes.
All right. And so at some point in the future, which we have rolling audits in these things, an audit took place and it determined not that the land wasn't suitable for, not that the size was too small, but basically that as an entity, they're not eligible because of the status of their entity status, correct?
That's correct.
And so that became a disqualifying event at that time. And then they looked and see when they became disqualified and went back all the way back to 2018 when it should have been discovered at the first time, correct?
Right. They never should have been put in through contingency.
They never should have been allowed to assume that. So it goes back to 2015, 16, and 17, which is the 3 years preceding 2018 when the transfer was made.
Correct.
And then they're also getting a bill for 18, 19, and 20 because they shouldn't, as a discovery bill. Is that correct as well?
That's correct.
All right. I'm going to let the county come back and tell us stuff more, but I think that the taxpayer gets to actually present their case. And I'll come back to the county. I just wanted to understand what was going on in this appeal. Does anyone from my board have any questions about the nature of this appeal before we go to the taxpayer? All right. Well, in that case, go ahead.
Chairman King, I just, before we go at the beginning, going to the taxpayer, can you get them to consent to this
Zoom conference?
Yep.
Yes.
Thank you.
Sure can. All right. All right. Since I think we understand the procedure, what kind of appeal we're dealing with today, And it is, just so everyone, sorry, I took my phone off the hook because I couldn't figure out how to put it on mute. Just so we know, we do have the authority to determine whether things qualify for the present use value program. And I think we do also have the authority to deal with penalties and discovery in the present use value program. So I think this is an appeal that is properly within the jurisdiction of the Board of Equalization and Review. All right, Mr. Sutton, are you there?
I'm here.
All right, I am going to turn over the floor to you. We have some materials here that have been submitted, and I see something that has your name signed on it. So I am looking at I've got something on Ag Carolina letterhead on here. A 2-page letter on here. And then it looks like some of the ownership requirements on there. And then there is a spreadsheet, which appears to be what the property taxes and the penalties and interest would be. That looks like to be the dollar figures that we're discussing today.
Yes, sir.
And let's see, there's a letter from Fields and Cooper. Did you submit that one as well?
I did.
Okay, and that's let's see.
And I can explain that as we go through it, but
I will. I just want to make sure that we've got the right amount of stuff on here.
Sure.
Then I've got a letter from Pitt County dated December 23rd, 2020, which I guess this is what you're appealing from.
that was the first time we were made aware of this issue. Yes, sir.
Okay. And then I've got a 2020 property tax bill. 2 pages, 3 pages. 3 pages.
That was what was sent with the letter that notified us. I'm thinking.
All right, and then after I get through those property tax bills, it appears to be that there is an email to you and to you and real estate attorneys, it looks like.
Yes, that email is related to the Fields and Cooper letter.
Yep. It's a pretty long chain on that one. And that appears to be it. All right, I'm going to let you go through that and tell us what Ag Carolina side of the story is on this track.
Sure. So for those of y'all who don't know me, I'm here.
Preston.
Yes,
do you consent to have your hearing? You can reserve your right to have a hearing in person at our chambers. Do you consent to having this via Zoom?
I do.
All right, go ahead.
All right. So for those of y'all who don't know me, my name is Preston Sutton. I'm the branch manager here at the Greenville office of Ag Carolina Farm Credit. And what we do is we lend money to farmers and farm-related entities, and that's our primary role. Some of the people y'all have heard talk, we have relationships with people who assist us in appraising property and doing transactions, attorney-wise. So, but in this case right here, the land that we're talking about, we purchased this property on May 25th, 2018, about 3 years ago. And the idea behind it was at some point to build an office there, which is actually what we're doing on 5 acres of the parcel today. The majority of it remains farmland, but there is the front portion is we're currently building a new office there. And so when in 2018, when we purchased this property, we had this same question that we're talking about here. Is Ag Carolina Farm Credit an eligible entity? And in looking at that, the email chain that you see and the letter that you see kind of is our documentation of where we tried to do some due diligence that if for some reason we didn't get accepted as an eligible entity, the seller had agreed to pay the deferred taxes. So we had this question, and when we submitted the application to the tax office, we asked them to make a ruling on it. So because we had backup that if for some reason we weren't qualified, weren't eligible, they would agree to pay the deferred taxes. We actually got a calculation of that, and I think that's included in part of what you got. Is something with there's a figure of $6,894.29 that I've got labeled as deferred worksheet, and that's the figure that's referred to in that letter. That if we found out we did not qualify at that point, they would agree to pay that $6,894.29. So we submitted our application. We did not hear anything back. It was, as far as we were concerned, it was accepted. And then we had our notice that we received in December 2020. That's the letter that you had. You know, at the end of the day, I can make a small qualification that we're eligible, but it's a weak argument in my opinion. And that was one of the things we discussed. But more importantly in our mind is, you know, we obviously try to be good owners, do what we're supposed to as far as property taxes. We wouldn't intentionally not pay something. And I think the proof of the email and the letter proves we thought about this. And in our mind, we feel like we're being punished that we asked to make a calculation. Nothing was heard back once we submitted. And now we're asked to pay, you know, penalties and interest as well as the taxes that we had made. I guess you would say we had made plans that they would be paid by the seller if that had happened in a timely manner. So in my mind, what I'm coming to this board and asking for is basically once we found this out, we talked through it, we made a partial payment that Ms. English referred to. We paid $12,215.13. And that was supposed to represent the the property taxes that we believed was from the date we took place, from the point of transfer, land transfer to the end of 2020. And so I guess what we're asking this board to do is to waive the penalties and interest that was charged, as well as the deferred taxes that that we had tried to make plans for the previous owner to handle if this had been handled in a timely fashion. I'm not claiming to know the eligibility requirements. You know, I looked at the present use stuff online. I can make a very weak argument that you know, when you say farmers and relatives, if you're leasing land, you know, how far back relatives go. But I mean, that's not my primary goal with this. We don't mind paying the deferred taxes. We just do not think we need to be penalized with the penalties and interest and the previous owners' deferred taxes that had we known if it had been ruled at that time, you know, they would have paid them. So,
Mr. Sutton, let me ask you a couple. Go ahead. Who just, I don't have the raise your hand button. Who would like to, someone from the board have a question for Mr. Sutton before I ask him a few? All right. So to understand your appeal, they have assessed you with deferred. So when deferred, just for the board's purposes, whenever a property is in deferred tax status, and there's no dispute, I don't think, from the county, which we still reserve the right to call the county to give their side of the story on this one. There's no dispute that the property was qualified in the deferred tax program in 2018. When the seller sells attractive land that's been in the deferred property program, two things can happen. Right. Number one is all the deferred taxes can be paid, which is you charge them the regular rate, which would be the rate without the deferred for that year, and then 3 years prior. So, and there's some interest on it because they're, quote, deferred. It's not like you never get them, they're just deferred. So, or the buyer can say, I will assume responsibility to pay these deferred taxes, and I'm going to continue in this program. And at that point, the buyer should send an application to the tax office saying, hey, you know, are we eligible? We are buying this property. Are we eligible to buy it and continue in the program? Okay, so, and if they're not eligible, then that is usually a seller's requirement to pay pursuant to the contract. Now, the tax office doesn't really care because it's a lien on the property, but in general, the seller is the one that's had the taxes deferred. And when they're selling the land, they're the ones that really owe the taxes unless the buyer is able to assume them. All right, so that's what's happened here. And what happened here is that transaction happened in 2018, right? And it didn't get caught in the system somehow until 2020. And so there is there are several components here. Number one is that the property taxes at the full rate from 2020, 2019, and 2018. Mr. Sutton, are you saying you've already paid those at the full rate? That's the
We
partial
paid-
payment?
No, we did not pay anything from past our point of transfer. So
Right.
from May 25th, 18 backwards, we did not
Right.
pay anything. From that date forward, we made the calculation $12,215 and 13 cents. And we paid it. Now, how it got applied, because our system, the people who pay this stuff is out of Raleigh, they sent it in. I checked this afternoon, and what they did is they actually paid it towards 2015, 2016, 2000. So if you're looking on the system, you're going to see
Yes.
those oldest ones paid, including penalties and interest, and the newest ones unpaid.
I understand, but you paid the amount equal to the non-deferred rate. You paid the amount equal for 18, 19, and 20. That's what, at least that's what I understand. that you've
From
done.
our date of ownership.
Even though they've been applying that to 15, 16, and 17. All right.
Yes.
But that's what, so there's really, I don't think much of a dispute as far as the principal amount, what it is and whether you paid it. We may have to deal with the application. But what you're disputing right now is you're saying Ag Carolina should not be responsible for 15, 16, and 17 because we did everything we were supposed to do back then. We submitted the application and the seller would have paid it if we were required to pay it at that time. So that's what we're disputing as the first part of our appeal. The second part of our appeal is we also are disputing any interest or penalties because we don't think it's fair to have to pay interest and penalties because we did what we were supposed to do. Is that an accurate characterization of that?
We believe we acted in good faith. Yes.
And theoretically, if the board were inclined to keep you in use value, you would prefer that as well, but you're not you're not shooting all your bullets on that one. You're saying, I
That's
understand. All right.
I'm
So that is
going for where
theoretically that is theoretically at appeal. Okay.
Yeah.
All right. Does anyone from the board have anything for the taxpayer? All right, Mr. Sutton, don't go anywhere. We will probably make a decision today, but I would like to hear from the county on this one.
Okay.
Lori, are you still there?
I am, and I wanted to clarify something,
Yes.
which I could tell by what you just said that maybe I wasn't clear about it.
Yes.
So I do see they did request those deferred amounts back then. There's a lot of email correspondence with Stephen Horn, who must have been doing the closing for this. And they did fill out an application for continued use with our office. And that application was approved. It was approved, but it should not have been. And so it wasn't complete. There was the business ownership part was not completed at all. And so I wasn't in charge of the program at the time. I'm not really sure what happened, but I just wanted to make that distinction that it wasn't that it accidentally just kept rolling forward. They actually did approve it for present use at the time. And so they did make application, and there was correspondence with Stephen Horn where, you know, we apparently our office provided those deferred figures, and Stephen Horn came back and said, okay, I'm just updating you that they plan on continuing to maintain it with deferred taxes. And so
Lori,
I do see that.
That approval is not in our pack. I don't think it's in our package of evidence in there, but you see that it actually is from 2018 and the tax office did. And
Yes,
we
sir.
certainly are. Yeah.
Yes,
They did approve it. And
yes.
because what I was going to ask was I saw correspondence between the attorneys. I wanted to make sure the tax office was notified of this.
Yes.
So you're
They
telling
did,
me.
and what I can't tell is who filled out the application, if it was someone in our office, but it was signed by Ag Carolina. So, I mean, we may have helped them. I'm not sure, or maybe they filled it out, but that business portion, because that's the first place I looked in the file is, well, what did they say they were? You know, how did they fill out that business portion to help me understand who they are? And it wasn't complete. And so it was based on that where I started doing the further research on it.
Well, it is thank you for being, that was not in our evidence package. So thank you for bringing, that was my biggest question on that.
Okay.
Other than Britt clarifying that, is there anything the county has to, Anything else the county wants to add to this file?
Not that I can think of.
Well, all right. Does anyone from the board that's not recused themselves, does anyone from the board have any questions for Lori? Okay, I'm going to go ahead and close this one to evidence. And all parties stay there. All right, this is an appeal of, this is a multifaceted appeal. Okay, this is an appeal. Number one, we have to determine whether Ag Carolina is entitled to use value. If we find Ag Carolina is eligible for the deferred tax program, then the whole rest of the appeal is out the window. I mean, they're eligible and they'd be in there. So that's the first thing we have to decide, right? If we decide they're not eligible for the use value program, right, we have to decide if they're not eligible for the deferred tax program, well, they're going to be pulled out of it. We have to decide what years to, theoretically, they should be liable for the deferred taxes for some period of time, right? It's usually the current year and 3 years. And they possibly may face interest and penalties. And at that point, we're going to have to use our equitable relief. We're going to have to decide whether this specific taxpayer is entitled to relief based on their actions. We have to decide whether we believe their story about what happened here. So I think taking this the first way, I think we need to, number one, identify and make a ruling whether or not we find Ag Carolina as an entity is eligible for use value purposes. All right, and we've heard from the county. The county's audited it and determined that they are not. The burden of proof would be on the taxpayer to show that they are. All right. Does anyone from the board have any idea about that? And Jordan, you can feel free to pipe in if you have any legal knowledge of this one. If you don't, I certainly have my opinions on it. So
I don't have anything to offer proactively. Here to answer any questions anyone may have.
All right. Well, does anyone from the board, before I get started on that issue, does anyone from the board have any opinions?
Mr. Chairman, in light of the fact that the county did rule that they had deferred status in this program, even though we don't know who that person in the county was, but then now the county comes back and says they weren't in the deferred program. I don't see how we can penalize the taxpayer for a quote mistake that was made by the county.
Well, Mr. Congleton, I think you're on the right track for the second part of the appeal. The first part of the appeal is, I think the easier part is, are they eligible for use value? I think we have to determine that first, because we say that what's happened is they were determined to be eligible back in 2018. And the county now says that was a mistake. Someone made a mistake there. We did approve them in 2018, but they're no longer approved as of 2020. So we have to decide as of 2020 or 21, I think the notice came out December 23rd, 2020. We have to decide from today going forward, are they eligible for use value? That's the first thing we have to decide.
Okay, right? I move that they are not eligible for the deferred status because they are not actively farming the land. They are a commercial lending business, so they should not be eligible for the deferred status, deferred taxes.
Before I ask for a second, I see a hand is raised on my computer, or maybe that's for me to click on. Does anyone have their hand raised?
Me.
All right. Just you?
Yes.
All right. Well, so Mr. Congleton's motion is to deny them for this appeal, deny them status going forward from 2020 going forward as to be eligible in the deferred tax program. John, do you have something to add to that one? John Shepard?
What?
Do you have something to add to that? You popped up on my screen. Are you raising your hand? Do you want to add something to that one?
No.
All right. I'm going to second Mr. Congleton's motion to deny them going forward on use value on and I'm perhaps I'm a little bit, what I bring to the table. I am somewhat of an expert in who's eligible for use value and not, and a corporation or a business entity, unless they're actively engaged in farming, like actually tilling the land, they have to be related party entities. My clients get so mad that they're not eligible for use value when they're like unrelated parties, like 6 or 7 guys, because a family-owned farm that could be in the same corporate structure can be eligible. I have known Ag Carolina for a long time, and I'm positive that they are not owned all by the same family. And they have testified that they're leasing the property out. So there is, if they're actively engaged in farming and on the tractor out there, basically, maybe you don't have to be related. But if you're just leasing your property out, and I'm pretty sure that Ag Carolina's predominant business is ag lending, I think there's no way ever that they were ever eligible for this thing. So I would support the motion to deny them use value from 2020 forward. Does anyone else have anything to add to that one? All right. Is there any discussion? The motion is to deny them from 2020 going forward. Okay. Does anyone and to remove them from the use value program? All right. Does anyone have any discussion on that? All right. All in favor of that motion, say aye, and we got to do it through a voice vote.
Aye.
Mr. King says aye.
Chairman King, aye. Chairwoman Huggins,
Aye.
Commissioner Congleton,
Aye.
and Commissioner Shepherd.
Aye.
All right. We've disqualified Ag Carolina from the use value program. Now we need to go back and figure out, they have been assessed with use value and use value is the difference between what the pure market value would be and the use value is used as farmland. So they've been taxed with the difference for 15, 16, 17, 18, 19, and 20, plus some penalties and interest on there. Okay, so we have to decide whether we're going to give them relief from this, because if not, they owe the deferred taxes for 15, 16, 17, 18, 19, 20, plus any penalties and interest. And I'm gonna yield the floor to Mr. Congleton, because this is where I think he was starting out on it. Go ahead, Ed.
Yeah. All right. Appreciate it, sir. So in light of the fact that there was an agreement with the seller, he would pay it in a timely fashion if it had come forward in short order. And in light of the fact that the county did give them deferred status in that, I move that we defer or negate the penalty and taxes for 15, 16, 17, because they purchased the property in 18. Is that correct?
That's correct.
All right. So 15, 16, 17, all taxes and penalty be negated. That's my motion.
All right. Does anyone have a second for Ed's motion?
I will second that motion.
All right. I'd like to clarify, and I am in support of that motion too, Ed. I'd like to clarify this because I believe the taxpayer, Mr. Sutton, testified that the Ag Carolina has figured out what the deferred rate would have been for 18, 19, and 20, what the actual fair market value was, right? And they've paid that, but I believe the county has applied those payments to 15, 16, and 17, which they should do generally. The county always applies things to the oldest tax bill. But if we waive the 15, 16, and 17 and say we're not going to collect that because the county messed up and they were lied, they changed their position on it because they could have just collected that money from the seller. So if we do that, I want to make sure that it's reflected to credit them the payment that they've paid that was to 15, 16, and 17 and apply it to 18, 19, 20. So I guess I would make a substitute motion to make sure that that's done. So to forgive the penalties and interest entirely, and for the deferred
and the taxes,
right? For 15, 16, 17,
yes.
and just make it be the rollbacks for 18, 19, 20, and the money that they've paid previously to either be refunded to them or credited to them as the office sees fit. But I don't want them to say, we got your money for 15. That one's in the books, but you still owe us for 18.
Any monies that are owed will be rolled into 18, 19, and 20.
Right. And any
Because
payments
that's what
made,
they pay for.
right. And any payments applied already to 15, 16, and 17 would be reversed and credited to that. So I got it?
Yes. Yeah.
All right. I'm in support. Does anyone, that's a substitute motion. Do I have a second to the substitute motion?
I'll second that.
All right. Is there any further discussion on the motion? Once again, the motion is to disregard the deferred tax, say that there are no deferred taxes owed for 15, 16, 17, to say there are deferred taxes owed for 18, 19, 20, to disregard any penalties or interest for 15, 16, 17, to disregard any penalties for 18, 19, 20. Interest is owed. Interest is part of deferred taxes. So that part's okay. And any payment that they made that was applied to 15, 16, or 17 to apply to what was owed in 18, 19, 20.
Yes.
Everyone got it? All right. Is there any discussion on that motion? All in favor, roll call.
Chairman King,
I am in favor of that. Aye.
Madam Chair Huggins,
Aye.
Commissioner Congleton,
Aye.
Commissioner Shepherd.
Aye.
All right, the motion carries unanimously. And I want to go out and, Mr. Sutton, you have a right to appeal this within 30 days, but I doubt you're going to want to appeal because I think we've given you the relief basically you've requested.
Yes, sir.
Certainly, if you want to appeal the classification of whether Ag Caroline is eligible for use value, you're certainly welcome to do it. I think that's pretty much the only adverse decision we made for you today. But you'd have 30 days from when you get your notice from the tax office. And I think you already know how to appeal since you've appealed this one. Go ahead.
I was just gonna say, I appreciate everybody's time. I mean, that was the biggest thing is obviously with what we do as a business, we want to make sure we're doing what we're supposed to as a landowner. I mean, that's what we ask our customers to do, with mortgages we have. So obviously we want to try to act in good faith. So I appreciate everyone's time and looking over this matter.
And I just also want to give a special thank you to Lori in the use value program. There is no way that you all should have been in this program to start out with. And she was not there at the time. The reason why we have audits on our use value program every 4 years, and I think that they audit them, they do 1/4 of the properties every 4 years. So I mean, that is absolutely what she's supposed to be doing. And we need to make sure that, that there's it is the use value program. We love family farmers, and I know you guys love family farmers too, but it is a family farmer, not a corporate farmer, but one.
And Ms. Laura was very helpful, when we talked through this and trying to get a good understanding. So I got a little bit of education because Jeremy and the appraisers on here know my specialty is lending. It's not it's not a tax law. So
well, it's a relationship, and trust me, I do enjoy our friendship. But I'd have ruled against you if you were, and you were definitely not going to get my vote that you were qualified for use value when I saw that one.
Yeah.
So, but I also want to commend Lori. One more thing is that document that showed that the tax office was not in our record, and it would have been hard to rule in your favor without the tax office admitting that the tax office approved that. And so I just want to say, whenever you're a judge of something and somebody presents adverse evidence, you just really respect, and this is, to the tax office. I mean, the tax office does a good job. Everyone makes mistakes, and we really do appreciate that candor, I would say.
Yeah.
All right. Well, Mr. Sutton, you certainly do not have to hang on to our Zoom for the rest of our meeting. I think they'll send you a notice, and we can go on to the rest of it.
I'm gonna get out of your hair, and I'll probably get in touch with Miss Lori and just make sure of how the money applies and all that good stuff. But I appreciate your time. I'm gonna leave you alone.
Thank you.
Thank you.
All right, Mr. Clerk, that brings us to old business. I don't have anything under old business. Do we have any?
We do not.
All right, new business, discussion of the adoption of discovery letters.
I don't know if you need any discussion, but I was reading through them and I would make the motion to accept them.
Well, let me pull it up. I had that up earlier. They look pretty good to me too. Sam, do you want to talk about these letters a little bit?
Yes. Steve Felfrey, he's general counsel for North Carolina Department of Revenue and works with the Property Tax Commission. He sent these to us yesterday. He was going to send them out in March, and he simply forgot to send them to us. And what we did as assessors, we just basically update these letters every year. But one thing that he did suggest that we have two letters. One is for notice of decision, and then the other letter is basically a notice of decision regarding discovery billings. And so that's their recommendation on what letters we should use whenever the board makes a decision. And so we're inclined to recommend that we use these letters as Mr. Felfrey with the Department of Revenue suggests that we do. And he has asked that, that the board adopts these, while they're in session.
I have a question.
Go ahead, John.
Are these documents for the board or are they for the assessing unit to sign.
They're for the board. The first one is to when we make a decision like the decision we just made, this would be a standardized document that we send to the taxpayer that gives them notice of what our decision is, and also gives them notice of their rights to appeal and how to actually appeal with statutory grounds and where to send it to. That's the second one. The first one, the discovery one, is also from us. It's talking about this is if we waive any discovery, or like if they just do a discovery and say they've discovered $150,000 worth of equipment, and we say, hey, it's only worth 102, we would send this and say, hey, your account number, we've made this decision, we determined it's worth this, or if we want to waive a penalty, it would be in that discovery billing one. So there's two different ones. They're both from us though, and it would be a more standardized format than what we have.
And if I'll just offer, the discovery letter, I believe, is totally new. The written notice of decision is very similar to what we currently use. And I didn't realize was created by NCDOR, but I believe it to be that the one we currently use was created by them. And I guess they've recommended some minor changes. So just offering that the written notice decision one's about the same as we currently use.
Jordan, do you have any problems with these letters? They look pretty good to me. What do you think?
No, I have no problem with it. Since it's, any appeal from this board would go to the PTC. It's a de novo appeal, so I'm not sure it really matters what the written notice decision says, but all the same, I have no issue with these letters at all.
I do like giving them a written notice of what our decision was. Sometimes people have a tough time evaluating what we actually did. So I'm okay with that, but you're right. It is a total de novo hearing, but they look great to me. I think usually I'm hard on the DR. Sometimes they look good to me. I would support adopting these. Does anyone else have any discussion about that? All right. I would entertain them. Go ahead.
I'd like to second that motion.
Okay. I'll make the motion, and we'll have Mr. Shackelford to second the motion. And is there any discussion on that? All right, the motion is to approve the notice of decision regarding discovery billing and get the name right, notice of decision forms as promulgated by the DOR and in front of the board today. Hearing no more discussion, all in favor of adopting these as our standardized forms, say aye. Roll call vote.
Chairman King,
Aye.
Madam Chair Huggins,
Aye.
Commissioner Piner,
Aye.
Commissioner Congleton,
Aye.
Commissioner Shepherd,
Aye.
Commissioner Shackelford.
Aye.
All right, carries unanimously, 6 votes. Great. All right, the next item on our new business is update on real estate appeals scheduled to be heard by the board. Sam, what do we have on real estate appeals?
I'm going to turn that over to Mr. Hill and let him explain what the real estate appraisers have as far as appeals that they're working on.
That sounds good. And I want to take this time to say he did a good job in your absence last time. We missed you, but he did a good job being the clerk to the board.
Great.
Good afternoon, board. I just wanted to update you on the status of since we have today is the 20th, the real property staff currently still has about 43 appeals that we're working through with the board. There was one taxpayer that has the bulk of those. He has about 21. We're still trying to gather information and work with the taxpayers so we can bring these to y'all either through appeals or consent agenda items, letters if we agree with anything that they're providing to us. And that count was as of about 2:30, 3 o'clock today. We could have had some come in since we've been in the meeting, but I just wanted to make y'all aware of that and let you know that we did have currently about 43 appeals that we're actively working on and trying to bring to y'all either through a consent agenda or appeal, hopefully, or withdraw if the taxpayer decides to withdraw one.
Russell, are any of these appeals ones that were denied last year? Are those taxpayers, do we notify them? Remember that we had some that were denied because they didn't appeal in time? Are any of those? Okay.
Yes, sir. The one that has 21 is one that was untimely for last year.
That's what I wanted to make sure that they got that we actually reached out to them and gave them notice of that. So I wanted to make sure of that. Okay. Well, that 43 sounds like a lot, but when you got 21 from somebody who was aggrieved last year, that's not so bad. That'd only be 22 that are fairly new ones, right?
Yes, sir.
All right. And when, I guess when is our adjournment date? Do you know when our adjournment date is? Sam, do you know that?
Yes, it's going to be May 4th.
Okay. All right. So more appeal, as everyone from the board knows, more appeals for real estate parcels can come in until we hit that gavel on May 4th. So, so we may get a few more. Hopefully the county can work through these.
Chairman King.
Yes, sir.
Actually, we're adjourned today, and our meeting on May 4th will be our last scheduled meeting to hear these appeals.
So in our published notice, it did say that today was the adjournment date.
That's
for real
correct.
property appeals.
That's correct. We've published that 3 times so far over probably the last 40 days.
I thought that might be the case. I couldn't remember, and to be honest with you, I haven't been reading the paper lately too much. But all right. So today is the last day for taxpayers to bring notice of appeal. All right. So the next thing that we added to this agenda was additional dates. So right now we're calendared to have a date on May 4th, and we have 43 appeals in process on real estate. Do we have any other discoveries or any other appeals in the hopper?
Not that I'm aware of.
But the feeling is we may need to add a date or two to go through these real estate appeals, or not.
Yeah, it just depends on how far we get May 4th, which we know that some of these we probably, like the 21, I don't feel like we'll have the taxpayer or us will be ready by May 4th.
Do you think one other additional date in May would be sufficient, or do you think it's more likely we're going to need 2 more dates?
I would think maybe just one additional date in May, maybe later in May would work. By that time, we should have all of our information together, or whatever information the taxpayer wants to provide. We can, I think that would be sufficient time. And then if not, we can always hear them in the fall.
Okay. All right. I think one additional date would be sufficient as well. Do we want to try to schedule that today?
The only thing we're going to have to do is work with public information to find out when's a good day for them to host that meeting, what's available. If we can agree to one date, then maybe by May 4th, we can come back and say, this is the date, and maybe add it at that time. We just probably will need, I would say, at least 10 days to notify, to run an ad in the paper though.
Okay. Well, how about this? How about we work through to coordinate a time where, we could have where it would be a good time to have the meeting. And on May 4th, we pinpoint that. We discuss it before May 4th, just whenever we send out the agendas to see if everyone's calendar would work on that one. And then we actually adopt the date at the May 4th meeting. Does that sound fair?
That should be, and I should be able to coordinate something with public information and maybe with Jordan as well to see what dates are good. But I would think maybe something like May 18th or May 25th, which are both Tuesdays at 4 o'clock. Hopefully them 2 dates, one of them 2 dates would work. And if you would grant us either of them 2 dates, then we can just go ahead and schedule it and go ahead and advertise it once it works out for the county.
That sounds fair to me. It doesn't sound like something that requires action right now until we pinpoint that date though. But my feeling is one additional date. Chairman Huggins, do you have something to add?
Yeah.
One meeting sounds good enough to you. One additional meeting sounds good enough to you.
Yeah.
Yes, I thought that would meet. With everyone's approval on that one. Okay, Sam, just have them send out notices of what days it could be. The 25th sounds good to me. I don't know. I guess Memorial Day would be the 31st this year. Is that right?
Yes, I think that is correct.
Well, the 25th seems an appropriate day to have a meet. That would work with my schedule, and it seems to be enough time from the 4th to the 25th to be able to get this last appeal ready to go. If that works with public information.
Doesn't work for me.
All right. Well, how about this? We will circulate and figure out what the day should be. We will poll the members. All right. Is there any other new business today, Sam?
There is none.
All right. Does anyone from the board have any new business to bring to our attention today? All right. Well, this is my favorite time of the year. Every year, I don't even really have a gavel here, and it's on Zoom. We're not, I don't get to look down the hallway, but is there any taxpayer, I guess, watching on YouTube? I don't even know how I would respond to this, but any taxpayer that wishes to bring a real property appeal to the Board of Equalization Review for tax year 2021, make your presence known today. I guess you would, if you're watching this, call the tax office in the next 3 minutes would be, I guess, the only way to do it. And let us know that you have an appeal to lodge as of today. If not, I would entertain a motion to adjourn as of 5 o'clock today and not take any more new real property appeals. Is there a second to that motion?
Second.
All right, Mr. Congdon, any discussion on adjourning for purposes of taking on new appeals? Once again, we still can hear the 43 appeals and any new ones that are lodged before end of business today. We can still hear those going forward. We're just not going to take on any new appeals. Hearing no discussion, all in favor of adjourning, say aye. Roll call vote. Roll call vote.
Chairman King,
Aye.
Madam Chair Huggins,
Aye.
Commissioner Piner,
Aye.
Commissioner Congleton,
Aye.
Commissioner Shepard,
Aye.
and Commissioner Shackelford.
Aye.
All right, gentlemen and ladies, we are adjourned for the year for taking new real property appeals unless someone calls in the next 3 minutes to the tax office. Okay. And we will see each other again on May 4th. That adjournment has taken care of any recess we have. So we are recessed until May 4th. I will see you guys later. Thank you, everybody.
Thank you.
Thank you.
Thank you.